Hi, everyone. Thank you for tuning in to this short video in our series on what I wish I knew about law school. My name is Kaylene Khosla, and today I'm going to be unpacking the question, how are law schools taught? As you may know, I'm a 3L transfer student at UC Berkeley School of Law, and previously I attended a different school in a different state for my 1L year. So I think I've truly seen firsthand how, regardless of what law school you go to, classes are taught quite uniformly, especially those doctrinal 1L courses. To help us understand the methodology behind law school teaching, I invited Molly Van Houweling, who serves as both a professor at Berkeley Law as well as an associate dean for the JD Curriculum and Teaching, to join us today. Thank you so much for joining us, Dean Van Houweling.
My pleasure. Thanks for having me.
Awesome. Well, I'd like to begin with a very broad question that many students, like myself, when first coming to law school might have. Why is law school teaching so unique, and what makes it so?
So it's a great question. And I think the premise of the question, that law school teaching is unique, I think it's true. I haven't surveyed broadly all fields of study, but I've always had that impression myself, that we put an especially high premium on teaching as law school professors. All professors have a wide variety of responsibilities, not just for teaching, but for doing cutting edge research, for managing the school itself. And I feel like among professors in other fields that I know, law professors really do put a high premium on teaching. And I think that's in part because, well, I think law students have high expectations, as they should, but why is that? I feel like all lawyers, regardless of how you use your law degree, let's say almost all lawyers, there are a variety of ways to use your law degree, but I think almost all folks who graduate from law school end up being teachers in one way or another, or at least they have to deploy pedagogy in their work, explaining the law to an audience. That can be explaining the law to judges if you're a litigator. It can be explaining the law to your clients if you're giving them advice. It can be explaining the law to students if you become a law professor. It can be explaining the law to juries, an especially challenging teaching task because the law might be really technical and complicated and the jurors might not be familiar with it off the bat. And so the lawyer's job in all of these contexts is to make what can be quite complicated and subtle rules and concepts understandable by an audience who might not be familiar with them. Even judges have to learn new things all the time. And so it might not be fresh in their mind, the specific law that they're being asked to apply in a particular case. And so the lawyers there might have the job of really educating the judges, or at least giving them a short refresher course on the particular topic. And so I think if you are a teacher who's teaching people who will become teachers, that puts a high premium on giving a great educational experience. So I think that that's part of the explanation.
No, I completely see what you're saying. And, I think taking very complex concepts and making them as simple as possible is law school in a nutshell. So thank you for saying that and recognizing that. I want to turn to one method of teaching that I have found, even as a 3L, is still really key to my learning process, and that's the case law method. So can you explain what exactly is the case law method and how is it used in law school?
Sure. Well, I'd say the basics of it of what most people mean when they refer to the case law method is we teach law school classes sometimes by assigning a lot of cases. That is a lot of written judicial opinions deciding cases that were litigated in a court. And the standard text, especially for a first year class, is a case book that's full of edited versions of lots of cases, often then with explanatory notes as well. And I think there are a couple of different explanations for why the case method continues to be so useful. It continues to be, I say that because it's a long tradition of teaching by this method, but that alone doesn't mean it's something that we should continue. And I should say that I think increasingly my colleagues and I use a wider variety of materials, even in basic first year classes, news accounts, podcasts, law review articles. So we're not about cases only, but I think it is invariably the case that many judicial opinions will be assigned, especially in first year classes. I think there are a couple of good reasons for that. One is that the case method, it's a way of teaching, but it's also a form of making law. That is, when judges issue these opinions, they often say that they're not making law, but the reality is that they are making decisions about how the law will be applied that then really form the body of the law, especially in some areas where there aren't statutes on the books, but nonetheless, there is something called the common law that is an outgrowth merely of judicial decisions where judges, considering one case at a time and considering the cases that have come before, that is the precedent, and following those cases, but then making adjustments because each factual scenario is different. So the judge has to grapple with, well, how will I apply these cases that have come before in this new factual scenario? I think the opinions really reveal how lawyers argue, what types of arguments are particularly persuasive, what counter arguments might you have to face. I think when I was a law student, I didn't fully get that part. I thought that my case book was full of the greatest hits, when that's not the case. No case book is written to only pick the very best, most admirable opinions. Some opinions in there demonstrate what a bad argument looks like, what an outdated mode of thinking looks like. They're danger signs as much as exemplars of legal reasoning. And so as I say, I think Berkeley Law students are eagle-eyed for that. And that's all part of the case method too, putting things forward that are ripe for critique, as well as showing good examples of legal reasoning.
Yes, thank you for such a thorough answer. And yeah, I have always found that cases are what make law school interesting. Like, I can't even imagine studying in a civil law system where you're just learning canon, just learning statutes, and not at all paying attention to cases. But yes, I would say it's also wonderful to see how law schools, even throughout my 3 years and transitioning law schools, seeing how much more active students are in critiquing and commenting on these different judicial opinions, maybe judges' styles in general. So that has honestly been one of the best parts of law school, is seeing that evolve. So I want to turn and shift gears a little bit. I know as an incoming 1L, and honestly still to this day, something that causes a lot of anxiety and nervousness about law school courses is the use of the wretched Socratic method. However, I also know that, once you get a little more comfortable with law school and how law school classes work, the Socratic method truly is some way to really enhance your education and make you understand the material better. So I'd love to hear your thoughts on the pros and cons of the Socratic method.
Sure. So I think people mean a lot of different things when they refer to the Socratic method. I mean, some are actually talking about Socrates and his method of engaging students through questioning. There's also a long tradition of using methods inspired by Socrates in the law school classroom. I think these days when people refer to the Socratic method, they tend to mean, generally, I think that the common denominator in the approaches is interacting with students through questioning them. I think really those are the basic components. And almost all of my colleagues use some form of that, interacting with students by questioning them. They rely to various degrees on something that's often associated with the Socratic method, the so-called cold call, where the people with whom you engage with your questions are not volunteers, but instead people who are put on the spot a little bit in the moment for that exchange. I think when you refer to the wretched Socratic method and the stress that it can trigger, that's probably the most stressful part of it. That was certainly true for me as a law student. I have various ways to try to make this less stressful and intimidating, and so to eliminate the disadvantages of this method. And different faculty members use different techniques for this. So some use what they refer to as a panel method, where only a subset of the students are on call on a given day, and the rest can relax a little bit or volunteer if they choose to. Some professors use a method where they reveal at the very start of a class session which students they will call on that day. So after that, you can breathe a sigh of relief, or you can like gulp a little more coffee and make sure that you're really ready to go. My own policy is to let any student just opt out for the day, no questions asked. So they just have to tell me in advance of class, and then I will take them off of the on-call list for that day. And then I think all of us try to make the exchanges themselves as humane as possible, because our goal is to enhance the learning experience, not to humiliate anyone, not to, sort our students in any way, but to make it a more rewarding experience for all of the students. And for me, the most rewarding experience is when, let's say, a few weeks have gone by in class, I call on someone who maybe hasn't spoken at all, and I don't know about this person. I can't tell because they haven't spoken how engaged they are, how closely they're paying attention. And then I call on them and they blow me away with their answer. And I think sometimes that's obvious how impressed I am with the student answer. And the most rewarding thing is when that student then becomes a regular participant in the class discussion, because maybe not entirely, they didn't volunteer for the first interaction, but it was rewarding. They were able to demonstrate their mastery, maybe even learn something as part of the exchange, and then they become a big contributor to the class discussion. So that's an extra way. I think calling on students makes the discussion more inclusive, not just because I'm calling on a wide variety of people, but because after having had a rewarding experience of talking in class, more students are enthusiastic about talking in class. And so even the volunteering becomes more inclusive and widespread after having used that technique.
That major point you make, I just want to say, really resonates with me, and I think is so important and relieving for a lot of 1Ls. I know just the educational environment I grew up with, and I experienced throughout undergrad and high school, and even before then, I have never been the first one to raise my hand and share my thoughts, even though I have a lot of them. And when it comes time for exams, I'm writing a mile a minute. So I have personally, though it is intimidating, just really enjoyed the Socratic method so far as it gives you that space where you have to participate. And then once you have that 3 seconds of courage where you get out the first few words, it's so much easier for the rest of the semester. So I think that is so true and could honestly be used in other areas of educational practice. One other area I'd like to talk about that I know a lot of incoming law students have, nerves and kind of questions about is grading. So could you talk a little bit about the different ways of assessing for grades and what that might look like at law schools, both Berkeley and outside of the UC system?
Sure. So one mode, especially in first year classes, and this was certainly the case in my law school experience. So let's start there. In the olden days, when I went to law school, for the most part, my first year classes went the whole semester with no evaluations, and then there was an exam at the end that accounted for most, if not all, of the grade. I would say that increasingly, and especially among my colleagues here, we are trying to inject what are referred to in educational lingo as formative assessments. So this is in contrast to a summative assessment, is the sum of everything at the end of the class, like a final exam. A formative assessment is some kind of intermediate assessment. So a midterm is a formative assessment, just to give one example. They're formative in that you're still learning, basically. So it's not just evaluating you, but also giving you feedback that you can use for the rest of the semester. interestingly, they're also formative for the professor because we see how effective our teaching is so far when we give a midterm. Midterms, however, are not the only form that formative assessments can take, and formative assessments don't necessarily need to be for a grade. So many of my colleagues, for example, use in-class polling techniques. So take sometimes even, and usually, an anonymous poll. This is a formative assessment because it gives the students a chance to test their knowledge. So it might be a poll that's basically like a quiz question. There's a right or wrong answer. So the students get to test their knowledge, see where they are. The faculty member gets to see where the students are. And many colleagues use this to gauge the pace of the class. Based on the poll results, they'll say, okay, everyone's mastered that topic, time to move on. Or sometimes they'll see, oh, students based on their answers are really struggling with this topic, so time to slow down. I think this is a big improvement from a pedagogical perspective because both sides are getting some feedback before the final exam. And even in a class where the final exam is the vast majority of the grade, I think it's really useful to take this pause to see how things are going. So students can assess their studying techniques, professors can assess their teaching techniques. Another thing that lots of colleagues do is take a sort of pause in the presentation of material at various points in the semester to have students practice with something that is akin to what a final exam question will be like. Final exams often feature lots of hypothetical scenarios, as I'm sure you have encountered. So we often refer to these as practice hypos, where the professor will throw out a hypothetical example and the class will work through it together. Sometimes professors give the opportunity to write up answers to hypos on which they give feedback, but it's also a form of feedback to present it in class, give the students a chance to discuss, and then present some ideas about what a good answer would include. So I think it still remains a big event in many classes, the final exam, that accounts for quite a bit of the grade, but it is not, I'd say the norm is not for it to be the first and only opportunity to test your knowledge, for the professor to get feedback and to try out some techniques. Also, it is especially unlikely to be the only form of assessment in upper level classes as opposed to first year classes. We have a wide variety of formative techniques across the law school curriculum, from papers to oral presentations to group projects. And so some people excel at exams. I didn't. It wasn't my strength as a law student. Some people excel in other things. And over the course of a law school career, there are, I was relieved to discover, lots of opportunities to demonstrate other types of skills.
On that same note, in that same vein, can we talk about some of the different learning pedagogies that happen, especially in those upper level situations?
We really do have a wide variety of formats for classes. So some classes are a relatively traditional lecture style, where you might be in a class of 60 students where a professor will give a presentation, although almost in every single class, even of a lecture style, there's an interactive component. That's really one of the things that's special about law school teaching, is that it always features interaction that gives the students this chance to try out their own kind of teaching and argumentation skills. So that's one format. We also have seminars, which there's actually a technical definition of a seminar in our academic rules. I think of the term more loosely as describing any class that's of a relatively small size, is more heavily dependent on interaction. The real bulk of the class might be discussion among students. Seminars also often feature guest speakers, so experts who come in to talk and lead the discussion on a particular topic. We have a type of seminar size and style class that we often refer to as a workshop, or sometimes a colloquium. Those are even more likely to feature guest speakers, sometimes every week. They will have a guest speaker come and talk about, often it's a guest scholar who's coming to talk about some cutting edge research and writing that they're doing. Sometimes they're practitioners to talk about their job in the law. So that's one format that really mixes things up in terms of getting to hear from a lot of different experts. We also have a variety of type of classes, all of which fall within the general umbrella of experiential. So this is the general idea is what it sounds like, learning by doing. So one subset within that bigger group is our clinics. We also have classes that are not part of our clinical program, but offer other types of opportunities to engage in real life clients. Those are called practica, which have a classroom component, but also a practice component. And then we have a variety of classes that don't have real clients, but are nonetheless learning by doing simulations of writing briefs as if they would be submitted to a court and doing other things that simulate real life lawyering.
I don't want to take too much more time and make this video too long, but one final question that a lot of incoming 1Ls have is, what should I be doing to prepare for this unique learning environment?
So I don't have a magic wand preparation skill. And I'd say really, I would err on the side of, this is my number one piece of advice. Take time with your non-law school things, not because you're getting ready to kiss them goodbye for 3 years, really the opposite, to make sure that those things are strong in your life so that you can continue to rely on them throughout law school so that you don't forget about them. So you keep maintaining a human connection that, humanity, I think, is the reason most people go to law school, but you can forget about it if you get buried in your law books. And so my advice would be not to do that, to hold on to, although your time will be perhaps seem full and limited, I think it's really healthy to maintain those connections. So I'd say cultivate them, especially if you have a little more time, but then keep them going even with the press of time that can happen during law school.
No, I think that advice is absolutely golden and was so true for me as a 1L, thinking of law school kind of like a job, like a 9 to 5 or 9 to 6, 9 to 7, doing it when you're doing it, and then turning off your law school brain and then finding the time to have a routine, to exercise, to spend time with family, to spend time with friends, to not talk about the law in those settings. Yeah. I found that to be critical. So thank you for sharing that pearl of wisdom. And thank you in general. I think that's all the questions I have and all the topics we're going to cover in this video segment. But it's been so wonderful to hear from you. And thank you for all the work you've also done at Berkeley Law to make it such a welcoming learning environment. I know I personally appreciate it, and so do all of my peers.
Well, it's my pleasure. And I hope I get to meet many of our audience members sometime soon.